Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back with the Truth Attack. Okay, so we are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating. So, if you enjoy the shows, the information, the discussions, the lectures, the revelations, the guests and the hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website, if you're not already there, listening through the online radio link, and get signed up as a monthly subscribing member. Every membership counts, and we do need your support to keep the broadcast network operating. And if you want to get fully informed on my favorite subject on this particular version of the Truth Attack Hour every Thursday evenings at 6 o'clock on the Liberty Works Radio Network, you need to find your way over to the taxfreedom.com website and start reading. And if you know anyone that needs help answering the IRS or the DOJ in court, you need to send them over to irszoom.com where they can get help answering the IRS correspondence for just $30, $40, $50 a letter, and answering the DOJ in court, challenging them, of course, on the version of the tax they think they're enforcing, which doesn't actually exist. And we're going to talk about that tonight. I think that rather than go through, I've been trying to read this for a couple of weeks now. You know, the Iranian war is winding down. They'll get the Straits of Hormuz open and the markets will get straightened out. Once they do, I think that's going to happen pretty quick here. The new Iranian regime seems to be at the breaking point and capitulating. I think they want the Iranian regime completely removed from power, but I'm not sure how much economic disruption or how long Trump wants this to go on. So we'll just have to see what they do to try to close this out. He's trying to persuade the rest of the world to take over operation and maintaining the Straits of Hormuz because, of course, they all get their oil through the Straits. We don't. We are energy independent. We get all of our oil from the U.S. or now from Venezuela. We don't need the Hormuz oil. And we can easily replace what won't come to us and let the rest of the world have it. But the rest of the world has got to have it. And without it, they're in trouble. And as long as the price of oil stays up, the U.S. economy will be hindered by it. Because even though we have plenty of oil, the people producing it aren't going to lower the price for America. They're going to charge what the world charges. So that needs to get straightened out. Okay, so a couple of weeks ago, I started reading from a petition to the Supreme Court that we are submitting here shortly to go after them on the fraud that they've been perpetrating on the American people. And I think that today I'm probably going to go ahead and reread the two little sections that I'd read before so we get the whole thing. Now, let's just get into that. And reasons for granting the petition. Moore abrogated the circuit court's holdings, creating a direct conflict in the circuit court's precedents that the full court declined to resolve en banc. Moore and the circuit court state and hold to irreconcilable constitutional propositions. The U.S. Circuit Courts of Appeals have all held for about 50 years now that the 16th Amendment authorizes a direct non-apportioned tax on United States citizens throughout the nation. But the Supreme Court held in Moore just 2 years ago that income taxes are indirect taxes under Article 1, Section 8. The Moore Court specifically stated that Article 1 of the Constitution affords Congress broad power to lay and collect taxes. That power includes direct taxes, those imposed on persons or property, and indirect taxes, those imposed on activities or transactions. Direct taxes must be apportioned among the states according to each state's population, while indirect taxes are permitted without apportionment, but must be uniform throughout the United States. Taxes on income are indirect taxes, and the 16th Amendment confirms that taxes on income need not be apportioned. But it also asserts, or rather the court has asserted, and so does the amendment by omitting the word direct from it, that the income tax is not a direct tax, which is how they've been enforcing it. But direct taxes have to be apportioned to the states. So they've been violating the Constitution blatantly for 65 years, assessing the tax as a direct tax without indirect basis. And more, the Supreme Court decision has pointed out blatantly and obviously this contradiction between what the income tax really is, an indirect tax that doesn't have to be apportioned, but it cannot be direct, and direct taxes, which must be apportioned only to the states. So the fact that they've been enforcing a direct tax against individuals is constitutional right out of the box for 65 years. And it's all black and white now. Nobody will discuss this. Nobody will argue it. No judge, no attorney in the country will refute these points. They're all proven. The government has put this all into documents and pushing it on the American people as frivolous position arguments since 1980. They openly declare the income tax is an unlimited direct tax, not apportioned, without constitutional limitation authorized by the 16th Amendment. That's what they've been forcing. Straight up communism. You work, you owe. That is not what indirect taxation is. Let's go on. Moore's reasoning traces to Brushaber and Stanton v. Baltic Mining in 1916, which established that the 16th Amendment prevented the income tax from being taken out of the class of indirect taxation to which it inherently belonged. That cites 240 U.S. at 18. And in Stanton, the court also declared that the amendment conferred no new power of taxation. No direct taxation, which would be a new power if it were unlimited. No new power. The circuit courts have inverted these decisions by reading Brushaber as authorizing an unlimited, unavoidable, direct, non-apportioned tax on all earnings. The circuit court decisions, it's a direct tax, and the Moore decision, it's an indirect tax, cannot be reconciled. Only the Supreme Court's intervention can resolve the dire constitutional conflict that now exists in every single tax case in the country, both civil and criminal, being prosecuted for income tax against individuals. Notably, 3 justices wrote separately in Moore to signal concern about the broader implications of income tax doctrine. Justice Thomas, joined by Justice Gorsuch, dissented and would have held that the 16th Amendment requires realization as a constitutional prerequisite, a position directly in tension with the prosecution for evading a tax whose constitutional basis was never established on the record at trial. Justice Barrett, joined by Justice Alito, concurred in the judgment, but wrote separately to emphasize that the majority's holding is expressly narrow and leaves open foundational questions about the constitutional definition of income and the scope of Congress's taxing power. These concurrences signal that at least 4 members of the current court recognize that Moore did not resolve and deliberately left open the constitutional questions this case presents. Petitioner respectfully submits that those open questions are squarely presented here. B, the en banc denial confirms the circuit will not self-correct. Petitioner presented the Moore indirect-direct taxation conflict and question to the full 4th Circuit in the en banc petition. Not a single active judge requested consideration of the question. The 4th Circuit has institutionally declined to identify or address whether or not previous precedential holdings of a direct non-apportioned tax survive Moore in the 4th Circuit. Every 7201 prosecution brought in the circuit under the direct tax theory now rests on a constitutionally erroneous foundation that the court has declined to acknowledge or correct, to be in accord with Moore and the doctrine of stare decisis under it. as the Tenth Circuit precedent of United States v. Collins, here and after Collins, was invoked and cited in this case in the government sentencing memorandum, it will be used hereinafter to refer collectively to all of the U.S. Circuit Courts of Appeals decisions holding that the federal income tax is a non-apportioned direct tax under the 16th Amendment, which is the holding in virtually every circuit in the country since 1980. Well, 80 is when it started, and they were all on board by 92. So, since Section 3231, oh, wait a minute. We're going to read this. Here we go. Let's see. What do we got? Yeah, let's read these. Okay, sorry. Where is it? Where did it start? Okay. C, the 10th Circuit's 3231, Section 3231 analysis is constitutionally insufficient. The trial court effectively held that Title 18, United States Code, Section 3231 alone supplies jurisdiction, regardless of the constitutional taxing theory underlying the prosecution. But this court has held, as regards all courts of the United States inferior to this tribunal, two things are necessary to create jurisdiction. The Constitution must have given to the court the capacity to take it, and an act of Congress must have supplied it. To the extent that such action is not taken, the power lies dormant. Statutes alone are insufficient. In the court, there must be a constitutional authority to tax that serves as the first plank to the subject matter jurisdiction. The statute is the third plank. The second plank is an authority in the Constitution given to Congress to write law. It's called the Enabling Enforcement Clause, and there isn't one in the 16th. So there's no authority to write law. That's part of the reason why the court said no new powers are created. How can a new power be created when there's no authority for Congress to write law to administer to or enforce the allegedly new power created? No, without an authority to write law, there can't be a new power because the courts can't enforce anything except what was there before and was enforceable under the original necessary and proper enabling enforcement clause of Article 1, Section 8, Clause 18. So, since lack of jurisdiction of a federal court touching the subject matter of the litigation cannot be waived by the parties, we must, upon this appeal, examine the contention, and if we conclude that the district court lacked jurisdiction of the cause, direct that the bill be dismissed. Section 3231 is statutory. It cannot confer subject matter jurisdiction over a taxing power that the Constitution does not authorize or grant. The Collins decision and all the other circuit courts' direct tax decisions and the IRS in making the assessment of tax specifically invoke the 16th Amendment, not Section 3231. As the constitutional authority for the income tax to be applied to individuals as a non-apportioned, unlimited, unavoidable direct tax on all the earnings of all persons, where the earnings are redefined as income. But they're not. There's no profit in an hour of labor. It's an equal exchange of blood, sweat, and tears for dollars. There's no profit on either side. The government premised this prosecution on the direct tax that was assessed by the IRS simply based on the defendant's earning money, and which assessment was not based on his conducting a federally taxable activity or transaction that was subject to indirect federal taxation by impost, duty, or excise. And the record is bereft of any such foundational evidence of a conducted taxable activity or transaction sufficient to support the claim that a tax was owed by the defendant. Okay, we'll be back in 5 with more. I think I hear that commercial break coming up. This is Thomas Freed on the Liberty Works Radio Network. We'll be back in 5 with more on more. Okay, this is Thomas Freed on the Liberty Works Radio Network, and I just heard during the break that Pam Bondi is out as Attorney General in the Trump administration. I'm not going to talk a whole lot about that, but I suspect that the controversy with the releasing of the Epstein files, or the delay when she got right up and said, "Oh, we're going to do that," and then it didn't happen for I don't know how long, and of course the utter failure with the Comey situation where they didn't get him charged properly before the statute of limitations ran out. I think both of those two things probably did her in. So anyway, Pam Bondi is out as AG. Okay, let's get back into what we were reading from the petition to the Supreme Court, and we're up to D. The Cromar citation underscores the need for this court's review, the Supreme Court. The 10th Circuit has already cited United States v. Cromar, citing Collins as precedent for rejecting Moore-based challenges. At least 2 unpublished circuit decisions now reject Moore-based challenges to criminal tax jurisdiction without engaging the Moore direct jurisdictional conflict with Collins and the other circuit court precedents being used. This pattern is foreclosing the constitutional question for all future criminal tax defendants in the circuit courts. Petitioner requests this court consider consolidating this petition with Cromar and or the other, or holding it pending the resolution of any relating cases. 2. The Fourth Circuit's jurisdictional analysis is constitutionally deficient and conflicts with this court's decisions. A, the nature of the tax is an essential constitutional element of a Section 7201 charge. IRC 7201 requires as its first element a, quote, tax imposed by this title, unquote, Spies v. United States. Whether a tax was legitimately constitutionally imposed is a threshold constitutional question. A criminal conviction for evading a tax mischaracterized as a direct unapportioned 16th Amendment tax, when the Constitution only authorizes an indirect Article 1 tax, rests on a legally deficient foundation, regardless of Section 3231's general grant of criminal jurisdiction. Quote, whether the tax is to be classified as an excise is in truth not of critical importance. If not that, it is an impost or a duty, a capitation or other direct tax. It certainly is not. And that cites Stewart and Machine in 1937. And this quote, I left out the quotes for each of the elements. It cites Pollock, Pacific Insurance, VZ, Pollock v. Farmers Loan, Knowlton v. Moore. These are all the cases cited sustaining the tax as impost, duty, and excise. But the 3 categories laid out and the declaration that it's not direct, just like in 1916 under Brushaber, this is 1937. The court again says impost, duty, excise, it's not direct. So the circuit courts have clearly had this wrong since 1955, when they started enforcing it as a de facto, and especially since 1980, when the de facto became a written precedent in the circuit courts. B, the indirect tax character has substantive consequences for Section 7201 prosecutions. Under the correct constitutional framework, income is the measure of the indirect tax of the form impost, duty, or excise. Stratton's Independent Supra. Income is not the subject of the taxation, which is the specific taxable activity or transaction conducted by the person, subject to taxation by impost, duty, or excise. The activity or the transaction is subject, not the person, because that would be direct. A prosecution for evading an indirect tax must identify the specific activity or transaction to which the indirect tax, as impost, duty, or excise, attaches. So you have to identify the activity in order to identify the nature of the tax. If it's foreign, it's impost. If it's export, it's duty. If it's commodities, license, or corporation, it's excise. If it's labor, what is it? I'm waiting. If it's labor, what is it? Yeah, that's right. It's an impost if it's the labor of a foreign person. But what is it if it's the labor of a citizen? It's not an impost, it's not a duty, and it's not an excise. There's no tax on your labor. The whole thing's a fraud. That's why they had to lie to you and tell you it's a direct tax under the 16th Amendment. There is no indirect tax that taxes your labor. The Collins Circuit Court's direct tax theory that all individual income is directly taxable without identifying any specific transaction or federally taxable activity is constitutionally wrong. The government at trial never identified the specific taxable activity or transactions conducted, allegedly giving rise to the tax obligation that the petitioner allegedly evaded. And this is how they conduct all the trials. They say, oh, look, he made money, he owes tax. They never tell you what tax you owe. They're claiming earning money is the basis for the tax. That's direct taxation. You need an impost, a duty, or an excise taxable activity. Foreign person, foreign import, in a foreign place, like a territory or possession, or in a foreign country under tax treaty. That's impost. Duty is taxing exported goods. We don't have any duties. That's why we have duty-free shops at the international airports. Excises tax the manufacture, consumption, and sale of commodities within the country, alcohol, tobacco, firearms, licenses to pursue certain occupations, alcohol, tobacco, and firearms, and the corporate privilege, where it is the privilege that is the subject of the tax, not just the earning of money. Where there's no privilege, there is no tax. Where there's no import, export, or foreign, there is no tax. Excise doesn't tax the American people's activities unless they're ATF related. And this comes from Flint v. Stone Tracy, 220 U.S. 107, 1911, 2 years before the income tax in 1913. In this case, establishing the scope and range of the indirect taxing powers, foreign, import, export, commodities, licenses, corporations, has been cited over 600 times and is now constitutional law. On a side note, one of the things Flint v. Stone Tracy appears to do is widow from constitutional authority federal estate taxation, which up until that time, out of cases in the 1880s, had been deemed to be based on excise taxation. But in Flint v. Stone Tracy, the constitutional authority for the scope of the power, they don't say estates are part of the excise. It's commodities, licenses, and corporations, which widows federal estate taxation from constitutional authority and foundation. There is no legitimate federal estate tax except on foreign persons who die in the country. Those are the estates under federal authority subject to tax. After Flint v. Stone Tracy in 1911, which widowed the 1880 decisions from constitutional authority, which had previously declared estate taxation as part of the excise power. Why? Where's the privilege? How does the federal government get jurisdiction over death? Isn't that God's domain? How dare you? Now you want to play God. Oh, of course. That's why they want you to pay every single time you earn something. Not to the church as a voluntary tithe, but to the men who play the masters of the universe. Or at least your master for now. The government never identified the specific taxable activities or transaction conducted, allegedly giving rise to the tax obligation that the petitioner allegedly evaded. The motion to avoid judgment that was summarily denied by the district court pre-trial would have compelled that required full disclosure of the subject matter jurisdiction of the court taken by compelling the disclosure of the underlying constitutional foundation for the claim that a specific tax was owed. The motion was denied summarily without explanation or establishment of a sufficient jurisdiction for the court to lawfully proceed under thereafter. They chose to not address the topic of subject matter jurisdiction and just swept it under the rug and conducted the whole trial without jurisdiction or ever telling the defendant what he was in court for. A direct tax, an indirect tax, impost, duty, excise, slave labor, peonage, why am I here? Oh, they wouldn't say. The judge was a crooked piece of crap. They all are, aren't they? Pretty obvious now, isn't it? Every tax judge in every court in the country handling tax cases is a goddamn piece of crap. C, the motion denial prevented constitutional testing. This court held in Russell v. United States, 1962, that an indictment must inform the defendant of the specific offense with sufficient particularity, referencing required compliance with Federal Rules of Criminal Procedure 7C. The motion to avoid judgment denial ensured the direct tax error never surfaced in the record of the action. The conviction was secured without the defendant petitioner ever being told with constitutional precision what specific form of federal taxation was being applied to his earnings, direct or indirect, as impost, duty, or excise. No constitutional foundation to the subject matter jurisdiction was ever disclosed or established. The court lacked subject matter jurisdiction to conduct the trial. 3, the procedural default ruling cannot stand where the ground was unavailable until more was decided. A, the Fourth Circuit applied no standard. The Fourth Circuit applied no test or standard in its affirmation of the trial court's conviction and judgment. The argument that Moore abrogated the direct taxation of income that has been erroneously upheld in the various U.S. Circuit Courts of Appeals for 45 years, as well as the invalidity of the IRS assessments of a direct tax on income, was not available to argue before June 20, 2024, when Moore was decided by the Supreme Court. The Circuit Court precedents were the binding precedent in the court up until that time. A defendant previous to June of 2024 could not have argued that a non-apportioned direct tax had been abrogated by a Supreme Court decision that would not be issued until 2024. But nevertheless, the fatal jurisdictional error requires correction. Cotton super. B, the en banc denial provides independent support. The full Fourth Circuit declined to be polled on the Moore indirect-direct tax constitutional questions, or the Moore-Collins indirect-direct tax question, and the argument was not available under the state of circuit law at the time of the prior trial proceedings. The Martinez principle, C, the Martinez principle supports relief. Martinez, you know what? I think we're coming up on the next commercial break here in less than a minute. So rather than start in on this paragraph, we're just going to go ahead and urge everyone to find their way over to the LibertyWorksRadioNetwork.com website. Get signed up as a subscribing member if you're enjoying the lecture today and the reading of the petition that exposes the judicial fraud that has been perpetrated in the federal courts for 50 years. By an intentionally fraudulent court that has avoided these issues honestly since the Supreme Court let them get away with these rulings in the 1980s. We'll be back in 5 with more on Moore. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. Let's just get right back into this. Okay, so C, the Martinez principle supports relief. Martinez v. Ryan, 2012, established that inadequate post-conviction proceedings may excuse procedural default of fundamental constitutional claims. The ground here was not merely undiscovered, it was legally unavailable. The district court's summary denial of the motion to void judgment was applied mechanically to foreclose a constitutional challenge that could only be articulated after Moore was issued. The constitutional conflicts and error were not addressed. That conflicts with the equitable principles this court has long recognized as supporting relief in circumstances of genuine constitutional error. 4. The direct tax error infected every stage: prosecution, sentencing, restitution, and collection. A, the first element of Section 7201 was never constitutionally established. IRC 7201 requires a tax due and owing as its first element, spies. That element requires a valid constitutional tax obligation, an indirect tax as impost duty or excise on realized gain from a specific federally taxable activity or transaction. The government never identified for any year charged the specific federally taxable activities or transactions allegedly conducted by the defendant giving rise to any indirect tax obligation in his name. It relied on the direct tax theory that all income from all sources is directly taxable without limitation as declared in Collins and all the other circuit precedents. Under Moore, that theory is constitutionally erroneous and incorrect. The first element of Section 7201 was never constitutionally established on this record. B, the restitution order is the direct tax error made concrete. The United States is not a statutory person eligible to receive restitution. The restitution order is constitutionally infirm on two independent grounds. First, every dollar alleged owed was calculated under the erroneous direct tax methodology. The amounts from IRS assessments treating all income as directly taxable under the 16th Amendment. The amounts were calculated from a gross income formula that by design identifies no specific federally taxable activity or transaction subject to tax, but merely assumes subjectivity to direct tax on all earnings, as well as the assumed liability for tax, which also does not exist in statute. A restitution order calculated entirely on a constitutionally erroneous taxing theory of an unlimited non-apportioned direct tax on individuals or their income, for which no liability is specified in statute that applies, is itself both constitutionally infirm and violative of law. Second, the United States is not a statutorily defined person eligible to receive restitution as a victim under any Title 18 statute, including Sections 3556, 3663, 3663A, and 3563B2, etc., i.e., the restitution statutes. The long-established canon of construction holds that the term person in a federal statute does not include the United States absent a clear congressional expression specifically including it, which does not exist. United States v. Cooper Corps, 1941. Congress has not expressed an intention to include the United States as a person in Title 18, nor in the restitution statutes, nor in the Title 26 taxation statutes. The Department of Justice's own guidance from the DOJ Criminal Resource Manual, Section 1048, acknowledges that governmental units themselves are excluded from the statutory definition of a person under Title 18, and by omission, from the restitution statutes as well. And that, quote, some financial losses are not eligible for restitution, such as state or federal taxes, interest, penalties, or fines, end quote. Federal taxes aren't eligible for restitution, but somehow every court in the country is imposing restitution on criminal defendants, forcing individuals to pay a direct tax that can only be enforced against the several states unless the judge is a communist. And then it can be enforced against the poor people, the uninformed, the uneducated. Straight up communism. Restitution for a direct tax that can only be collected from the several states. But now you got to pay restitution for a direct tax. You'll be a slave to the federal government for the rest of your life. The judges just made this up. They made everything up. They made up the direct tax. They made up the authority under the 16th Amendment. They made up the authority to write law. They made up the liability for a direct tax, which isn't in statute. What's in statute is the indirect liability for the collected tax that's been collected from the foreign person subject to the tariff. That was enacted in 1913, the Underwood-Simmons Tariff Act of October 3rd, 1913, the original legislation that enacted the federal income tax. Collection of the tax at the source. Citizens are the collectors. They're not the subject of the tax. And gross income, the list of definitions they're using to, a list of source items they're using to claim you owe tax on rent, dividends, interest, alimony, salaries, wages. That legislation originated under Canadian tax treaty and applied only to people working in Canada. That's a fraud too. This is all judicial legislation and constitutional fraud. Every single bit of this entire fraudulent tax. Every single bit. Okay, where were we? The Department of Justice, we did that. Additionally, even accepting the direct tax premise arguendo, a non-apportioned direct tax on income cannot be constitutionally enforced against an individual. Under Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4, as Moore confirms in its reaffirmation of said constitutional limitations, i.e., all direct taxes must be apportioned among the several states in proportion to their population under the last census. A restitution obligation premised on a direct tax that the Constitution requires to be assessed and enforced only against the several states cannot lawfully be enforced against an individual defendant. The $10,000 fine extends the direct taxation theory error. A sentencing, the direct district court imposed a $10,000 fine on defendant that further perpetuates the direct tax error independently of the criminal judgment. A chain of instruments, each link of which derives from the unconstitutional direct tax error, cannot impose fines or other collection instruments based on an ungranted and thus unenforceable taxing power, i.e., a non-apportioned direct tax. A fatal constitutional defect in the underlying taxing theory is a constitutional defect in every instrument derived from it, and is thus fruit of the poisonous tree, as the non-apportioned direct taxation of individual persons is constitutionally prohibited. More supra. 5. The conviction and all derived instruments are void for lack of subject matter jurisdiction. A court lacking subject matter jurisdiction cannot proceed in the action to try, convict, sentence, fine, render judgment, or order restitution, lacking that required subject matter jurisdiction. This court has consistently held without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is the power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. Ex parte McCardle, 1869. The requirement that jurisdiction be established as a threshold matter springs from the nature and limits of the judicial power of the United States and is inflexible and without exception. Mansfield, C. and LMR Company v. Swan, 1884. For a court to pronounce upon the constitutionality of a state or federal law when it has no jurisdiction to do so is by very definition for a court to act ultra vires. Steel Company v. Citizens for a Better Environment, 1998. The criminal prosecution of the petitioner was expressly premised on an unconstitutional direct tax and taxing theory that Moore confirms does not actually exist as law or valid constitutional taxing theory. The Constitution does not authorize a non-apportioned direct tax on income that is to be enforced against the individuals earning the income. It authorizes only the indirect taxation of specific federally taxable activities and transactions by impost, duty, or excise taxation. The government never identified any such taxable activities or transactions that were allegedly conducted by the defendant to properly establish the taxability of his evidenced earnings. The court that allowed the trial and jury conviction and then imposed sentence and ordered restitution be paid did so under an erroneous claim to a non-existent constitutional foundation and authority to tax directly and without limitation. Under the authorities above, the conviction and all instruments derived from it are void. Defects in subject matter jurisdiction require correction at any and every stage of the proceedings. Cotton Supra. 6. This question presents questions of national importance that the 10th Circuit is entrenching through unpublished decisions. The scope of Moore in criminal tax prosecutions. Thousands of Section 7201 and Section 7206 prosecutions are brought annually under the erroneous direct tax theory framework, premised on the erroneous theory that the 16th Amendment authorizes a direct non-apportioned tax on all individual persons and their earnings. Moore directly contradicts that theory. The question of whether Moore's characterization of income taxes as indirect Article I taxation affects the constitutional validity of this prosecution and of all such prosecutions, and what the government must identify to establish the first element of Section 7201 under the correct indirect constitutional taxation framework that does exist, has enormous national importance affecting all pending and future criminal tax cases in every district and circuit court in the country. B. The trial record demonstrates why national guidance is urgent. The trial record in this case demonstrates the enormous, erroneous constitutional consequences of leaving the indirect direct income tax question unaddressed and unresolved in this and other tax cases, when it was properly resolved under Moore, but remains unapplied in the circuit courts, because the circuit courts are refusing to apply the doctrine of stare decisis and implement the decisions taken in Moore within any tax case ruling that they make. The circuit court's direct tax methodology, I think you hear the end of the show coming up. I guess we're going to have to finish this next week. I still got a couple of pages to go, and I like it, so we're going to come back to it. This is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. We will be back next week with more on Moore and the rest of the petition. So tell your friends, neighbors, family, gather around, get informed, learn the truth,